Hi, I'm Jarrah with eLaw Alliance.
And hi, I'm Herman Jangri. I'm also with eLaw Alliance.
And today we wanted to talk to you about the court process after you've been charged. Today's video is going to cover a lot of general questions. Please note that we're not providing legal advice in this video. We're going to be answering very general questions in a very general way. If you do want specific legal advice, please give us a call at our office. We will provide you with a half-hour free telephone consult. But let's start on some questions. Herman, you practice criminal law, right?
Yeah, and we run into a lot of these type of questions, so we'll go over some of these and perhaps you can provide a few answers for these. So, just starting out, you've just been charged with a criminal offense, you have a court date coming up, what should you do?
Definitely you need to attend your court date. So you will be informed of when your court date is, what courtroom it's in, and what time you have to be there. So just make sure, pretty simple, make it to court. If you are not able to make it to court, don't just leave it at that. Make sure you send someone to go for you. That could be either a lawyer or even just an agent, somebody you know, to let the court know that you are there and what you're looking for on that particular day.
So you sort of did touch on this, but what would happen if I don't go to court?
If you don't show up to court, there is a very good chance that the court will note it and then issue a warrant for your arrest, and then you'll have to deal with another criminal offense called failure to appear. So that's a really good reason why you should go to court, otherwise you face more criminal charges and a warrant out for your arrest.
So on my first court date, what should I do to prepare?
Definitely you want to make sure that you are attending court on time, that you're properly dressed. Courts are places that are pretty formal, so as much as possible, come to court, clean clothes, not in your pajamas, don't wear any baseball caps, and you're not going to be permitted any kind of food or drink in the courtroom other than water. So those are some tips to know about your etiquette in court.
So once I do get to court, it can be quite overwhelming. There's a lot of people there. So could you maybe just explain who are these people that are in court, the Crown Prosecutor, the judges, and perhaps duty counsel?
Sure. So there are different players in the court system. Obviously, there will be a judge in your courtroom. He or she is going to be presiding over the matter. There's also likely going to be a Crown Prosecutor there representing essentially the state and dealing with all of those cases. You're going to run into a bunch of defense lawyers as well. And there's also a lawyer at the courthouse called duty counsel. Duty counsel is a free lawyer provided by legal aid that can assist you on your court date if you don't have your own lawyer. The thing with duty counsel, though, is they're only going to help you out for that one court appearance, and they're just going to give you a little bit of help. If you need more substantive help, you should definitely consider hiring your own lawyer.
So as we're speaking about our own lawyers, who are legal aid lawyers, who are private lawyers, and what is student legal services?
Sure. So if you're looking to obtain legal representation, there are a few places you can go to, some of the ones you just touched on, like legal aid. If you make below a certain income and the type of offense you've been charged with meets the criteria, you could go to legal aid and apply for one of their lawyers. They are a system of certificates where they send out certificates like contracts to other lawyers, and that lawyer, whoever they pick for you, will be your assigned lawyer. And in some cases, you can actually request your own lawyer. If you've got a particular lawyer in mind, give the name to legal aid and they can try to set you up with your own lawyer that way. You can also, if you don't qualify for legal aid, do any kind of search online and find criminal defense lawyers and hire them on a private retainer. Obviously, it'll probably be more expensive. It will be more expensive for a private lawyer, but that's another option if you don't qualify for legal aid. And then there is also another option. Student Legal Services here in Edmonton also assist with certain types of files, usually the ones that are less serious. So if you don't qualify for legal aid and you don't make a lot of money, Student Legal Services might also be another bet for you.
So if I'm at court and this person that made the complaint against me, will they also be at court when I go?
On your first court date, it's very unlikely that the complainant, the alleged victim, is going to be there on your court date. Normally, the complainant will be there on the trial date, not on the what we call docket days.
So one of the terms you hear often is to put a matter over or to adjourn it. What does that exactly mean?
So adjournments are very common. Essentially what an adjournment means is that you're putting your matter over. So if your court date is June 1st, you attend, but you need some more time to get a lawyer or to get disclosure, you would be requesting an adjournment. And the judge will normally grant it if it's your first court date and that'll give you more time to get your case in order. So you can ask for an adjournment. It's very common, but there's also a maximum. You can't just keep adjourning your matter endlessly for months. Eventually the judge, once you've been given a reasonable amount of time to get your matters in order, will eventually tell you no further adjournments.
Now, one of the things you mentioned was disclosure. What is disclosure?
So disclosure is basically the case against you. It's any police notes, witness statements, video surveillance, anything that the Crown or the prosecutor is using against you, any evidence that the police collected is going to form part of your disclosure, and you're entitled to a copy of it. You definitely need to order a copy of it so that you know what the case is to meet.
And are witness statements and things like that in disclosure?
Yeah, definitely.
Okay, and one of the other things mentioned is an ECR or an offer. What is that?
So ECR stands for Early Case Resolution Offer. This is the terminology we use here in the criminal courts in Edmonton. And ECRs are basically an offer from the prosecutor wherein they will suggest what your sentence be should you plead guilty. Just because you receive an ECR doesn't mean that whatever the sentence is in it is what you're going to be sentenced to. It's just what the position of the prosecutor is. That's what they are going to suggest your sentence be. Of course, you can negotiate that sentence. You can request a different sentence. You don't have to accept that sentence. You can take it to trial if you would prefer to do that instead.
So one of the terms you hear here is summarily or indictable. I'm in charge with a summary offense or an indictable offense. What's the difference between those?
So those are categorizations of crimes in Canada. In Canada, there's essentially three ways to classify crimes. One way is to classify them as summary, which usually are your less serious offenses. Another way classification is called indictable. Those are normally your more serious offenses. And then there's a third classification called hybrid, and that is when the prosecutor is permitted to choose either to proceed summarily or by indictment.
Is there any reason why they choose summary or indictment if it's hybrid?
There is. If the facts lean more towards the serious side, or there's some aggravating factors at play, prosecutors will often then proceed by indictment. Versus if the facts themselves are not as serious or as aggravating, then they have the option to proceed summarily instead.
Okay, so now I have my disclosure, I have my offer, I know if it's summary or indictable. What are my options? How can I resolve my matter? So
there are at least three ways I can think of how to resolve your matters. Number one, you want to ask if you are eligible for a program called AMP. That's the Alternative Measures Program. It's a program designed to allow certain people with certain types of offenses to participate in community service. And then once that community service is completed, oftentimes the charge itself will be withdrawn. With that particular program, you have to qualify for it, and usually the more serious offenses are not going to qualify for it. But it is an option if you are not dealing with a very serious matter. Your two other options on how to deal with your matter is to either enter a plea of guilty and proceed to sentencing, or you can enter a plea of not guilty and proceed to trial.
So I've been released and I have conditions, but I don't like these conditions. I want to change them. How can I do that?
In order to change any bail conditions or conditions of your release, you need to talk to the prosecutor. The prosecutor has the discretion to reopen bail or reopen your conditions in order to amend them or to cancel them altogether. So you would have to talk to the prosecutor about that. You could either get duty counsel to assist you with it if you don't have your own lawyer, or you would hire your own lawyer, and that lawyer would help you negotiate with the prosecutor to reopen bail.
So one of the situations we often run into is a person is charged with assault against their spouse. Their spouse tells them, I don't want to do this anymore, I don't want to proceed. Does that mean the charge doesn't get withdrawn against them?
Your spouse, even if you were charged with domestic violence, your spouse does not decide whether or not the charges get withdrawn. That decision lies squarely in the hands of the Crown prosecutor. And there are many occasions where a complainant will take back what they say or not want to proceed with the charges, and they will vocalize that to the prosecutor. And the prosecutor doesn't necessarily withdraw the charges right away. Sometimes they'll wait, let things settle before they decide to withdraw it or not. In some cases, they'll refuse to withdraw it for a variety of reasons, including if they think the complainant is being intimidated or trying to withdraw charges for a reason that might be of concern to them. So it's not up to the complainant to withdraw the charge, it would be up to the prosecutor.
So a lot of times we get these situations where somebody is at their first appearance and they say, I'm just going to explain to the judge exactly what happened and the judge will believe me and it'll be done. Am I able to go to my first appearance and tell my side of the story?
In most cases, your first court appearance is what we call docket. Your matter is going to be one of several other matters that are being heard that day. And no, you don't really get to tell your judge your side of the story on a docket day. That day is just meant for you to organize yourself, hire a lawyer, get disclosure. It's not a case where you can relay your version of events to the judge. He's or she is not going to be interested on a docket day. When you get your chance to tell your side, if that's what you choose to do, that would normally be at a trial date or in some cases during a guilty plea when they read in the facts.
So we had mentioned this earlier, if I have conditions, for example, I have a curfew, and if I don't follow that curfew, what's going to happen to me?
If you don't follow the conditions of your release and the police find out or it's reported to them, they have the authority to charge you with a breach, and then you're dealing with yet again another criminal offense. And in some cases, being charged while you're already on release will create a scenario where you might not get bail next time around.
So I know there's several different courtrooms here in Edmonton. Could you explain what these courtrooms are?
So in Edmonton, just real briefly, we do have different courtrooms that do different things. For example, courtroom 265 deals with all of the in custody matters. So people that were not granted bail or where bail was not spoken to, their matters are going to be in courtroom 265. We also have a courtroom 268 that handles exclusively domestic violence cases. Courtroom 267 deals primarily with federal offenses related to drugs, and courtroom or CMO, the case management office, is it is technically a courtroom, but it's actually at a counter, and that's where you can go to deal with your matter. And then 357 is mental health court. So those are some of the courtrooms that you might run into at the courthouse.
So one of the options we hear is to get a preliminary inquiry. What does that mean?
So a preliminary inquiry is basically a forum wherein you can see the case against you play out, like the complainant might come and testify, the police might come to the preliminary inquiry and testify. It gives you a chance to see your case, see where the evidence or lack thereof is, but no decision is going to be made on your guilt or innocence. It's just an opportunity to basically review the case. If there's even a little bit of evidence to support the charges, it will then proceed to the next step, which would be a trial.
Okay, and what's a bail review?
A bail review. So let's say you are granted bail, and one of the conditions of your bail is that, or let me backtrack. Let's say you were denied bail, and you want a second shot at convincing a judge to allow you to be released because you have a new release plan or new information. That sets you up for a bail review. Basically, it's an opportunity to review the denial of bail and give you a second chance to try to get bail. But there are certain requirements you have to meet to get a bail review. You don't just get it because you didn't like the decision. You have to be able to show that there's some new information that wasn't present at the original bail hearing that is now present to justify a court taking another look at it.
So let's say after I see my disclosure, I decide to plead guilty. They have enough evidence. What happens at a guilty plea?
So at a guilty plea, the judge will expect you to enter the guilty plea itself, to take responsibility for the elements of the offense. Sometimes the prosecutor and the defense lawyer will work out exactly what facts you're going to plead guilty to. And then once you admit to those facts, the next stage will be sentencing. And oftentimes the defense lawyer and the Crown prosecutor will have an agreement on what they think your sentence should be. Ultimately, though, the judge makes the final decision on what your sentence should be.
So how about the opposite way? I see disclosure, I see there's not enough evidence, I want to go to trial. What happens at trial?
So at trial, that will be an opportunity to hear all of the evidence. So the police will testify, the witnesses will testify, the complainant might testify, and even in some cases, the defendant will testify. After all of the evidence is heard and closing submissions are made, the judge presiding over the matter will then decide whether the Crown has met their burden of proving guilt beyond a reasonable doubt or not.
I think that's been a pretty good overview of exactly what happens in the criminal court.